Hi friends, this is Naavi of Naavi.org coming to you with a small discussion on the WhatsApp privacy policy issue which came up for hearing at the Supreme Court today. As some of you may remember, way back in 2017, WhatsApp introduced a modified privacy policy both for Indian users and global users, and suggested one policy for Indian users and another for the EU users. It was felt that the policy for Indian users provided less privacy protection than the policy for EU because they had to comply with GDPR at that time in EU, whereas in India they could say that there was no equivalent legislation to protect the privacy of Indian users. Apart from the requirement or provision for the personal data collected through the process to be shared with Facebook or their other parent company or their associates, which was one of the contentions which created some kind of a stir. There was also a point that the dispute resolution mechanism suggested that the disputes should be settled in a court outside India. In EU, of course, the Ireland is the place of jurisdiction. For the other third countries, which included India, the jurisdiction would have been the Californian or the US court. We have discussed this sometime back in Naavi.org website earlier. We will make reference to it in greater detail later. Now, the government of India has withdrawn the PDPP 2019 and made an assurance that they are in an advanced stage in finalizing the new replacement bill, which is more comprehensive, and it will be produced for public comments maybe in the next month or so, following which the modified bill, that is the bill modified with the incorporation of the public comments, could be tabled again in the parliament in December 2022 and taken up for passing in February 2023 during the budget session. This is the schedule which we feel could be used by the government of India. Now, the WhatsApp issue, which is that of a privacy policy of an intermediary, whether it is a diluted privacy policy and a discriminatory privacy policy between the users of the same application in India versus elsewhere, and the issue of jurisdiction. These are the two specific issues: discrimination for providing lesser protection and then the jurisdiction. Whether that dispute needs to await the new data protection law is something which we need to debate. Now, Information Technology Act after the 2008 amendment has got section 43 capital A, which is followed by the reasonable security practice, and section 79, which is followed by the rules on due diligence. There is a specific guideline about the privacy policy, and there is a general understanding of what is privacy and what should be the due diligence which should go with a privacy policy. So with or without the new PDPB, there is a very clear understanding of what is the due diligence of as far as the privacy policy is concerned. The PDPB, the new version which comes, cannot be expected to give a chapter on WhatsApp privacy policy. In fact, it will perhaps address privacy in a much larger sense and go into compliance related issue, out of which there are a couple of issues which directly addresses the intermediaries like WhatsApp. One is the identification of the origin of a message. Second is the KYC for the users of the message or the services. In fact, the certain guidelines of 28 April has already given certain directions regarding the subscribers' details to be maintained by such an intermediary platform and the KYC wherever it is required, because WhatsApp is also going to have financial transactions. So the certain guidelines come under the Information Technology Act. As a result, as of now, WhatsApp needs to follow Information Technology Act 2000 as amended in the year 2008 and the rules notified in April 2011 regarding the reasonable security practices for protection of data, as well as the due diligence to be followed for collecting the personal data, processing the personal data, and for transferring the personal data outside India. Therefore, there is no need to wait for the new act to come in order to find out what needs to be done for the WhatsApp issue. In fact, even if the new bill is presented in the month of December, it may or may not be possible for the act to be passed in the month of February, because it may again be referred to another joint parliamentary committee and it may take a little more time. Therefore, when the pleadings are made to the Supreme Court, for which a date like December 15th has been given, for the final hearing which has to take place in January 17, the persons who are submitting the pleading will not be able to say clearly whether India has got any data protection law beyond ITA 2000, which has been in existence from, at least say, as far as this aspect is concerned, from 2011 rules. The Act amended in 2008 with effect from 27th October 2009. The original Act itself being available from 17th October 2000. So, beyond what is present in ITA 2000, ITA 2008 and these rules, the persons who are submitting the pleading will not be having any other reference legislation to say this is what WhatsApp should do or can be permitted not to do in terms of protecting the privacy of the Indian citizens. If the right to privacy of Indian citizens as described by the Supreme Court is the right of choice to determine how the personal data has to be collected and processed by a third party, then the privacy policy, if it fits in to the role of, let us say, an informed notice and a proper authenticated consent given, it fits in to the law as of now. The problem in the whole policy is as far as the grievance redressal is concerned, where the company, which is a company established in USA, comes to India, does some business and tells the Indian citizens, I will not give you any grievance redressal option here in India. If you have a problem, you come to California. and file a case against me. In fact, this aspect is the critical aspect which the Supreme Court should address and leave the rest of the privacy policy issue for being determined on the basis of the concept of due diligence. And for arriving at the due diligence, one can make a reference to the best practices in India, best practices in EU, or whatever is referred to in the PDP bill, which in the past has been referred to by high courts in Chennai, high courts in Orissa and Delhi in respect of the right to forget, when there has been instances where this particular bill has been referred to. Now that has been withdrawn, but even the withdrawn bill shows the legislative intent, and for the purpose of determining the due diligence, it has got its own value and it can be considered. So therefore, the task before the Supreme Court would be mainly to look at the concept of discrimination and this jurisdiction, two important aspects. And we can recall here the issue of a case which happened in Kerala High Court, where the Kerala government contracted to get the COVID data, personal data, which was sensitive personal data, processed by a US company under a contract agreed to on the website, which said that if there is any dispute, Kerala government has to go and file a case in USA and there will be no remedy here. And at that time, the Kerala High Court did point out that such contracts are unfair and cannot be accepted. So that will now come for a review now with the Supreme Court, and not the overall aspect of the data protection law. However, knowing the way media reacts to this kind of a case, probably there will be an undue pressure now on the government that they have to come up with the new draft of the law before December 15th, so that the persons who are pleading will have a certain guidance about what is in the mind of the government. We don't know whether it will happen. If this particular requirement hastens up the production of the bill, it is fine, it is good. However, in a hurry, the government should not come up with a bill which is not as comprehensive as it is expected to be. In fact, those of you who are following the series of articles which I am providing under Naavi.org on the shape of things to come and placing our views on what this law should be, one clear point which we are making is that we should try to design the law on the basis of providing rights to citizens. So we should first define what is the right which we are guaranteeing to the citizen, and then say how this law is going to provide that protection of the rights. The other laws, like the GDPR and others, have not clearly adopted this kind of an approach, or let us say, whatever approach they have made did not give that much of focus on rights-based designing of the act. More or less, they went into making a law to regulate the personal data processing which happens within a geographical region. It is also an acceptable approach. Only thing is, there is a difference between regulating the industry and the industrial activity called personal data processing, and providing the rights to the citizens, such as the right to privacy and the other subordinate rights. In fact, as an example, we can say the telecom bill, which again a draft is now presented and is available for public debate, is a bill which is more tuned to regulating the industry, such as licensing of the telecom operators, spectrum, right of way, and so on. The aspect of providing and protecting any rights to the individuals is not the subject matter of this industry regulation called the telecom bill. Whereas the law which is being proposed as a data protection law, the core focus is privacy protection. As of today, there is no statutory law on privacy protection. We are all trying to interpret the Supreme Court intention and say privacy is protected as a fundamental right under the Constitution, but nowhere it is stated either in the Constitution or in the statute. In fact, this will be the first opportunity when the government actually drafts this new data protection law to make a clear legal provision that we in India to protect by law the right to privacy, and then go further to define what is this right to privacy, whether it includes the physical privacy, the mental privacy, the neuro privacy, or anything else. So defining the objective of this new Data Protection Act as protection of right to privacy, and then defining what is privacy, is the condition precedent before we take up the rest of the provisions of this data protection bill, which may say whether you should have a data protection impact assessment, privacy by design, what kind of penalties are to be imposed, what is the data breach notification time, whether it is 6 hours or 12 hours or 3 days. These are all actually secondary issues. Before that, we have to define privacy and say this is the right which is being guaranteed by this particular law. Now, because of this pressure on the government now with this particular case, I will not be surprised if the government thinks of making a greater emphasis on social media intermediaries and how to regulate them, which actually should come. Of course, it has already come under the telecom bill because the WhatsApp is being defined as a telecom operation. So it will come under the telecom bill. Licensing will be required for WhatsApp, and the terms of licensing will be defined by TRAI under the Telecom Act, which may include protection of the privacy of Indian citizens. Now, apart from this, Information Technology Act, if it comes in a revised form, there is the Section 79 Intermediary Liabilities Safe Harbor, where again there is a possibility of this social media intermediaries to be covered. It's already being covered now, and the definition of significant social media intermediary, etc. These are the things which are subject matter of ITA 2000. In fact, this was included in the 25th February 2021 notification on intermediaries, which also obviously is with the court, because anything which the government does, even before it is put into practice, it is always being referred to by courts. And until the court clears, the day-to-day activities of the Ministry of Information Technology Department is unlikely to proceed. So now, with this new guidance that December 15th something has to be presented, and January 15th or 17th there will be some kind of a final hearing, the government will be at a loss to know what it has to do with the data protection law. In fact, it is quite possible that having included the definition of WhatsApp in the telecom bill, the government may actually try to gloss over this social media intermediary controls in the data protection law and leave it to be decided by the Telecom Bill and the Information Technology Act revised, which may come later. So we are in a situation where we don't know what is the law being to be applied. We don't even have a clear understanding of what is the core problem, but perhaps a serious debate in the constitutional bench of the Supreme Court is going to happen, and something will come out of it. And if, because of all these uncertainties, unless the Supreme Court, after starting the hearing, takes a decision to consider the situation a little more closely, we may have a forced decision which may not be the most perfect decision of the highest court of the land. I wish the court takes a step back and looks at the issue and try to decide what exactly it wants to hear on January 17th, and not be completely committed to the decision that a final decision will be taken, unless the final decision is to tell WhatsApp that it is premature to take a view on the particular decision. We will have to wait for the act to come in. But from the academic perspective, we are in a very interesting situation where a law is being prepared and a discussion is happening in the court at the same time, and one will complement the other. And definitely it is interesting to see how things will turn out. Thank you. We shall continue our discussion as and when it is required. This is basically an attempt to clarify the issues on hand. Otherwise, we will wait for what the court decides and then take a view on how it will impact the users. Thank you.